I'll go ahead. 22 CP 211905, Antoine McCray, battery, family violence, first offense, and financial transaction card fraud. When he gets out here, Mr. Pennington, if you want to go ahead and put it on the record.
Sure.
So you may, can you be excused?
Yes, if we're not having a prelim, yep. So,
Absolutely.
You can be excused.
Okay. I got good news for you. Let the ADA say what he's got to say, but then I got good news for you. All right.
All right. Stay safe out there. Get some rest.
Yeah, well, hold on. I got good news for you. All right. Let the ADA talk, and I'm going to tell you what's going on. It's good news. Okay.
All right. Go ahead, Mr. Pennington, on Antoine McCray.
Yes, for this case, Your Honor, the state has learned through its victim witness advocate that the victim in this case found the credit cards which were the subject of the theft and indicated that they were not stolen. So for that reason, the state does not intend to prosecute the financial transaction card theft, which is the only felony on this case.
Mr. Go ahead.
So, Your Honor, we understand that. We would ask the court, therefore, then to, I guess, dismiss that charge, or, ADA Pennington to file a null pros on that charge. And then I would ask Your Honor to transfer the case to state court through that, because that would be the only felony on the case.
Yes, and Your Honor, the state would ask the court to dismiss this the felony charge, and does not oppose transferring the remaining misdemeanor charge to state court.
Does he have a bond on the battery, family violence?
He does. It's currently $20,000. If Your Honor would be willing to hear it, I would ask the court maybe.
Address that bond. Didn't you transfer it?
Yes.
Okay. Is that okay with you?
Yes.
All right.
Oh, actually, hold on one moment, Your Honor. This case was recently in front of Your Honor on an ORCA calendar, and he's saying that it's lower than that at the moment.
Oh, that's correct, Your Honor. You just saw that. So the state, there probably is no reason to address the bond on this.
It looks like the bond order hasn't been filed for some reason. So it's still showing as 20,000 in Odyssey. It shows that it hit the ORCA calendar on Tuesday, actually, on the 13th. But there's no bond order in the system. So it's still showing 20,000 right now, but he says it was lowered to 10,000. I was not the attorney who covered that hearing, so. Okay. Yeah, so on the 13th, he went and he says it was lowered to 10,000 on the battery charge and 2,000 on the financial transaction card theft. So the bond would currently be 12,000.
All right. So then that's fine. If it did, I don't know why it's not in here yet.
Yeah,
I see it. I can put it on the system now.
We're gonna get it in
Oh,
for you
okay.
right now.
You see it?
Yes,
And it's 10,000.
yes, it'll be 10,000. Well, yes, it's 10,000 for the battery.
Okay.
But with 10,000, I can also get an approach.
So that's fine. It can. So you're going to file a no price on count two?
Well, it would be it's really just, I guess we would NPGJ it and then transfer it. If you could
Okay.
transfer it now, we can do it, but if you're able, since there is a bond, if you can just transfer it now, that would work too.
Yeah, as long as there was a bond. So we can transfer it now without bond, and whoever it gets assigned to, I'm sure they'll get him back on pretty quick.
Judge, I need a dismissal with that or the decline before I can transfer, because it's still going to be showing until I get a decline or dismissal.
Yeah, Mr. Pennington, you're going to get us a dismissal?
Okay.
Yes, we can do that. Well, then we can't decline one charge. We just have to NPGJ it. So,
Or whatever you can do, you can decline
Yeah.
one, but yeah, get her a dismissal so it'll get it off, because if it goes now to state court, they're just going to send it right back.
right. We wouldn't be opposed if you wanted to dismiss this for lack of probable cause at this point either, the charge just from the court. I'll file it. I'll just have to go back to my office and do it. I won't be able to do it right now. So, and that's fine. Either way.
We're fine with either mechanism, Your Honor, just as long as, preferably today, the charge gets dismissed as far as bond purposes for him being able to try to make
Just visit Ms. Holmes for bond of prosecution. And that way it can get transferred. That way it'll be a little neater, because I wouldn't want it, jam him up.
Okay, I'll do that. Thank you, Judge.
Just deals with misdemeanors. I want to try to get him in jail.
When he finishes with that, we can.
Yes, Your Honor. Thanks for handling that first.
Sure. Either one of you work overnight? Nice. Which case are you here on?
Hold on, I'm looking here too. You got two.
You're here for Sharita Milborn, is that correct? Yeah, Sharita Milborn, that is position number 3.
All right, if you come on up, we'll take you first.
Really quick, Madam Pretrial, before they take Mr. McCray in the back, are you able to see what the reason for a hold is?
A moment, please.
Because he has a hold from Cobb County, and he said it's College Park, because it should be like Cobb County, and he, as far as he's aware, has no business over there. So just trying to figure out what answer to give him.
Okay, and it's not listed in the GCIC council.
Okay.
I don't see anything on Odyssey. But I mean, hold on, did you see it on his bookend sheet?
It's a College Park PD hold, which makes me think they may have they may think they have a warrant for some reason. It's on his booking screen, yeah.
Was this this one out of College Park?
It doesn't.
This was College Park PD that did this.
So you're saying they're both in the same, it's the same probation. Okay, then that's probably it. Hopefully when we get you to top, we'll just resolve it quickly and get you moved on. But I'll try to work on that. I'll try to get some information. But it says College Park. But it says College Park PD, so.
And Mr. Lane, College Park PD made this a
Right, so that's what I'm trying to figure out, if maybe just these warrants were never listed as closed in their system, or if there was something else going on. But I'll work on that and get you some information on it. For now, like I said, let's work on getting that 10,000. If we can get that out and get you out, then we start trying to fix these holes, and you and I work. Right. There's no way I can get holds off. They do holds, and that's their business. I have no control over what they do. Okay, well then, for at least for now, one of them is someone who is dismissed. Now you're only going to them have been accused of a misdemeanor charge. So we'll try to figure it out. Okay. I'll try to get you some more information once I have it. I haven't looked into them yet, so I don't quite know. Right. I'm going to call her today. She's out of the office. That's the reason I'm covering cases. So I'll call her today and get it from her. And then if I can get it to Mr. Pennington. But for now, I'll call Ms. Cole as soon as we get to calendar work. Okay. Like I said, I'll call Ms. Cole and figure it out. I have to get that information from her. And I can do it right now. Even if people do it. But after the calendar, I'll call Ms. Cole and start working on that first thing. Okay.
Yeah, and nothing showing up on Odyssey on a warrant, but we'll go through this and see what the status is. On
10,000.
position 1, Mark McLeod.
Your Honor, the officer is on the way. He's stuck in traffic, but we know the officer's on the way.
Stuck in traffic in Atlanta, no way. Roderick Jung.
Your Honor, the officer is here. The stage is ready to proceed.
All right, and then we've got position 3, Sharita Milburn. The officer's here. Jason Dunges.
Your Honor, in this case, the officer has a conflicting subpoena for a probation revocation hearing. The state's not opposing that. This is over 90 days. So if you wish to hear bond, the state does not oppose hearing bond in this case.
When's the probation revocation hearing?
It's today.
Did you know a time?
I can look that up, Your Honor. 9 a.m.
Oh, okay.
in Jackson, Georgia.
Oh, okay, it's not here. So you just want to address bond again on that one, Mr. Lang? I know we addressed it in September.
Yeah, Your Honor, first I would have a motion for the court just based on this is the second time this case will be getting reset. But I do say they brought out Ms. Milborn, so if we want to handle that after we handle some of the prelims. I'm also okay with that.
All right. What about position 6, Damian Bradbury?
Bradbury, Your Honor, the state is waiting on the officer to appear, but we've been in contact with him and we anticipate his appearance.
All right. Asia Hill?
Your Honor, the state is waiting on the officer to appear. We don't have any updates on when that might be.
All right. And Theodore Maltzby?
Again, the state is waiting on the officer to appear. We don't have any updates on when that might be. Smith. Okay, so Your Honor, the Officer Smith, which is, let's see which case this is. McLeod. Oh, yeah. So that's position
Position 1.
1 is here. Thank
All
you.
right.
Here, hold on a second.
So since this officer worked overnight, this is going to be Sharita Milburn, right, ma'am?
Yes.
All right, it's 22 CP 211633, Sharita Milburn, theft by taking felony. And let's see. Did you print this out today? No, I'm just wondering if this days is right. There's 108 days, but let me check. Oh, okay, 108 days without indictment. And there is a $5,000 good bond as of 8/20. All right, go ahead, you can swear him in. Sarge?
Do you swear affirm the testimony you should give to the purpose be the truth, the whole truth, nothing but the truth to help you God?
Yes.
Have a seat. You can please state and spell your name for the record.
Officer Kimberly Anaya.
You got that, Madam Court Reporter?
Yes, ma'am.
Okay, thank you, officer. Go ahead.
Good morning, Officer Anaya. Where are you employed?
For the city of Atlanta, I'm sorry, for the city of Atlanta Police Department.
Okay. And in what capacity are you employed with the City of Atlanta Police Department? Like, what's your role with the City of Atlanta?
I patrol. I'm in a patrol unit.
Okay. And how long have you worked for the City of Atlanta Police Department?
For about 2 years.
2 years. Okay. And were you working in that capacity on August 18th, 2022?
Yes.
And were you post-certified on that date?
Yes.
Did you become aware of a Sharita Milburn on that date?
Yes.
How did you become aware of Sharita Milburn?
That was when when we got the call regarding a vehicle that's been in the parking lot for a couple hours now, I believe. I made contact with her once I realized that the vehicle, sorry. So the vehicle on our system that we have, which is Mark 43, it turned out that they made a report about a stolen vehicle. So I made contact with her once I saw her inside the vehicle.
Okay. And what happened after you made contact with her?
I have asked her for her information, her name, and the reason why she was in the vehicle.
Okay. And did she give you any indication of why she was in the vehicle?
Yes.
What did she tell you?
She stated that she was inside the vehicle because she had found the key and on the door by the keyhole, I believe it's called. She said that she found the access to the vehicle, so she went inside the vehicle and drove off with the vehicle.
Okay. And do you know, did she take the vehicle as she described to you on the same day, or was that indicated?
If she took the vehicle in that same day?
Okay. And what was the location where that you found her with this vehicle?
That will be at 2283 Baker Road.
Okay. And is that in Fulton County?
Yes.
Okay. And were you able to determine who the owner of the vehicle is?
I did.
Okay. Do you have the owner's name?
I do. I'm sorry, I'm trying to look it up.
It's okay. Take your time.
Joseph Longo?
Okay. And did Mr. Longo report the vehicle stolen?
With the other officer, yes.
Okay. And did Mr. Longo indicate if he had given authority to Sharita Milburn to take the vehicle?
He did not.
Okay. Thank you. And in the warrant for theft by taking, you say that the vehicle has a value of $1,500 or greater. How did you determine that value?
I don't recall. I honestly don't remember how I.
Do you believe that the vehicle had a value of $1,500 or greater?
Yes,
And what is the basis for that belief?
based on the fact that it's a vehicle.
What type of vehicle was it?
It was a Jeep Grand Cherokee 2009.
2009.
Yes,
In your experience, is a 2009 Jeep Grand Cherokee worth more than $1,500?
well, I pay for, yes,
Okay. So when you took out this warrant for this, did you believe that the value of the vehicle was over $1,500?
yes.
Okay. Thank you. All right. Do you see Sharita Milburn in court today? You can stand up if you need to.
If everybody could remove their mask. Everybody in the courtroom, just remove your mask real quick.
Yes.
Could you please identify Sharita Milburn for the court? You can point, describe.
Over there.
No, you gotta like,
Describe and point.
like 5'10", 300 pounds. You gotta describe who it is.
Oh, dark skin, has braids. Is that?
What else? What
She's
are they wearing?
I'm sorry, she's wearing her a dark top with a white shirt underneath.
Okay. That,
Sorry.
let the court know for the record that the witness identified the defendant in this case.
All right, so noted. You can put your mask back on. Thank you.
Okay. The state has no further questions for this witness, subject to redirect.
Cross.
Good morning. Was it Officer Anaya?
Good morning.
My name is Attorney Lang. I represent Ms. Milborn. I'm going to ask you some questions and also follow up on some of the questions you were asked by ADA Pennington. To start, I want to talk about, I guess, your conversation with Ms. Milborn on the scene. When she made these statements to you, was she in handcuffs?
Yes.
At that time, was she free to leave?
At the time, yes.
So when you were asking her questions, she could have just walked away and not answered
But
those
she was-
questions?
I'm sorry. She was in handcuffs. I was talking to her. I was trying to figure out what was going on with her. So if she hadn't, said what she said, she would have, until further investigation, but
So was she detained at that time?
yeah, she was detained.
And were you asking her some questions kind of about what was going on, why she was in the vehicle?
Yes.
Okay. And all the statements she gave were in response to your questions?
Yes.
Had she been Mirandized prior to being asked these questions?
No.
No further questions, Your Honor. Ready for argument.
All right,
No further questions, Your Honor.
all right. Argument.
Your Honor, I'm asking the court to dismiss all charges, or dismiss, there's only one charge, so to dismiss this charge. The primary evidence in this case appears to have come from my client's statements. The officer even stated, had she not made those statements, I probably wouldn't have arrested her. Those were un-Mirandized statements that were asked through questioning. So those statements are going to get suppressed through a motion to suppress once this case gets indicted. Additionally, the officer said they're able to say the value is over 1,500. It sounds like pure speculation about it's a vehicle, therefore it's worth over 1,500. We don't have an actual value, and we don't have any reason that she's able to come to this evaluation. We heard no expertise in cars, not even expertise. We heard no experience in cars. Whether she's ever purchased a Jeep Cherokee before, and that's how she happens to know the vehicle value or anything to that effect. So at the very least, I'd ask the court to lower it to a misdemeanor since we have no concrete evidence as to value. But based on the fact that it seems like the primary evidence in this case is un-Mirandized statements questioned out of my client, I'd ask the court to dismiss the charge.
Mr. Pennington?
Yes, Your Honor. There may be a motion to suppress to come later, but that's a matter for a later hearing when the state will be able to bring video evidence, which would have, to support any, or if the state chooses to dismiss at that point, any evidence that relates to Mirandized statements. At this point, this is a probable cause hearing. The officer had probable cause for the arrest in this case. As to the value of the vehicle in this case, Your Honor, the officer was able to state that in her experience that a 2009 Cherokee would be over $1,500. Should Your Honor decide that that does not meet probable cause for a felony and changes that to a misdemeanor, the state would ask that a charge for entering auto be added in this case, which is a separate felony, and that it remain in Superior Court. Entering auto requires entering an auto with the intent to commit a theft or a felony. In this case, we do have a theft, and a auto was entered.
Anything else?
Your Honor, the only information that supports that is not information that rises to probable cause. That is not lawfully obtained information.
I agree. I'll tell you what I'm going to do is I'm going to leave it at theft by taking, and yeah, I agree. Motion to suppress hearing is going to be interesting, and I'm definitely going to hear bond. You can be excused, officer. Quick trial. 119 days, excuse me, Mr. Lang, without indictment.
The defendant has 15 cycles. The defendant's last arrest was July the 19th, 2018 in Seattle, Washington for assault and resisting an arrest. There was no disposition for that arrest. The defendant also appeared to have an outstanding hold out of Tombwater, Washington for escape. The date on that warrant is July the 26th, 2018. The defendant does have prior felony convictions out of Washington. One in 2014 for felony domestic assault, one in 2013 for domestic violence, a felony. And there's one misdemeanor conviction that was in 2008 out of Washington as well for domestic violence. Nothing in addition, Your Honor.
Go ahead, Mr. Lang.
Yes, Your Honor. One moment while I get the right sheet in front of me. Ms. Milborn is 33 years old. She is a high school graduate. At the time of her arrest, she was unemployed due to being in custody for over 100 days. There's no job in the pipeline at this moment. However, she's previously worked in both the fast food industry and with Amazon, both of which should be relatively easy to find a job in upon her release. She's lived in Georgia for the last 4 years. The address on file is a good address for her. Looking at everything we have here, especially based on the evidence we have in this case, I'm asking the court to convert the bond to an unsecured judicial release through pretrial at level 2. Otherwise, I'd ask the court to reduce the bond to $1,000.
Mr. Pennington, and so it's 420 Cortland. It's good for her.
That's correct.
All right, Mr. Pennington.
The state does not oppose a reduction to $1,000 given the evidence we've heard today.
All right. $1,000 good bond. And let's see, no further contact with, stay away from 2283 Baker Road, and no further contact with Joseph Longo, Longo. Best of luck to you, ma'am. Who would you like next, Mr. Pennington?
Your Honor, we have, did any of the officers, I didn't talk to you, Detective Smith, you didn't work, did you work overnight? We were just. Okay.
You've had sleep, is what we're trying to get at.
Yeah. So
What about you?
we'll go ahead and hear the other case then. Yes, as that officer was here first.
Marshall, what's case you here on?
Yes.
Position 2. Roderick Young. Position 2, Roderick Young. Since that microphone's crazy.
All I did was move it about half an inch and then I got feedback.
Sir, are you here on behalf of a victim's family or a defendant? Okay. All right, this is position 2, Roderick Evan Young, 22 CP 211631. 119 days without indictment. The charge is aggravated assault. And let's see. There's a $30,000 good bond as of November the 29th. Go ahead, Mr. Pennington.
Is the officer Benz?
Do you swear from the testimony you should give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Got you. Will you state and spell your name for the record?
Officer LaQuisha Marshall, LaQuisha Marshall, Marshall.
Good morning, Officer Marshall. Where are you employed?
City of Atlanta Police Department,
Okay. And in what capacity are you employed with the City of Atlanta Police Department?
patrol officer.
Okay. And how long have you been with the City of Atlanta Police Department?
I've been with the city 2 years.
Okay. And were you working in that capacity on August 19th, 2022?
Yes,
And were you post-certified on that date?
yes,
Did you become aware of a Roderick Jung on that date?
yes.
How did you become aware of Roderick Jung?
I was dispatched to a 911 call at 234 Memorial Drive. It was in reference to one of the residents in fear of his life. He stated that Roderick Young pointed a gun at him directly in his face and stated, "I'll shoot you." This was in regards to a dispute, like a verbal dispute that had earlier or sometime right before he pointed what appeared to be a gun in his face.
Okay. And you mentioned that one of the residents indicated this, a resident of what sort of facility or?
Oh, it's called the Welcome House. I believe this is like a
Is it some place that people reside?
yes, it's a place where people reside, but it's I just can't think of the name at the time. It's a specific name, but it's a place where numerous people reside.
Okay. And what was the name of this resident that that advised you of this?
His name is Humphrey Ellington.
Okay. So let me just back up. You did speak to Mr. Ellington, correct?
Yes.
Okay. And did you speak to anyone else?
Yes, I spoke to Miss Rochelle Watson, Miss Dana Harris. Yeah, Miss Dana Harris.
Okay. And
Oliver Garrison.
okay. And what did Miss Watson advise?
They were advising that one of the residents approached her and was like, I need a handgun for my protection. I'm scared of one of the residents. He threatened me. He pointed a gun in my face and he was going to shoot me. And then that's when she called 911 and myself and another officer came out to the residence to just figure out what was going on.
Okay. And then when you spoke to Mr. Ellington, did he relay the same facts that Miss Watson had?
Yes.
Okay. Did he add any other details?
The other detail, it was just stating that I believe Mr. Young wanted to smoke with him and he didn't want to smoke. He didn't want to be bothered at the time. So that's what led to it.
And then the other witness that you spoke to, Oliver Garrison, what did you learn from Mr. Garrison?
Mr. Garrison basically just restated the exact same thing that Humphrey Ellington stated.
Okay. And then were there any statements that that any of these witnesses indicated that Mr. Jung had made?
Any statements? Yes. The statement was, "I'll shoot you."
Okay. And who heard this?
It was, I believe, Oliver Garrison. Yeah, Oliver Garrison. He was with Humphrey Ellington at the time.
Okay, thank you. And then what happened? So after you learned this information, what did you do next?
Myself and the other officer, we reviewed some video footage
Okay.
that correlated with Mr. John going to the door. Well, going to Mr. Ellington's door, banging on the door, and then as the door opens, you see him reach in his pocket and then enter the door like in an aggressive manner. After that, we tried to conduct a knock and talk on Mr. Jung's door. He didn't answer, but he ended up coming down the hall. We approached him, identified him as Roderick Young. After that, we detained him. He was Mirandized, and we asked if he wanted to answer any questions. He denied. Then he was just placed in my custody, and we notified one of the aggravated assault investigators of what took place.
Okay. And on the video, were you able to see the gun on the video, or? It
appeared to be a black gun. It was also on his person. The gun that Mr. Ellington described was the exact same gun that Roger Jones had on his person.
And how were you able to find the gun that was on his person?
Yes. So after he was detained and read his rights, we searched incidents to arrest. We searched him and we found the gun. Okay.
And what kind of gun was it?
It looked like a handgun, but it turns out it was a BB gun or a pellet gun of some sort.
Okay, thank you. And this location, 234 Memorial Drive, is that in Fulton County?
Yes.
Okay. Did you, let me ask you, do you see Mr. Jung in court today? You can stand up if you need to.
Everybody can remove their mask for us, please.
Yes, Mr. Jung is right there with short, appear to be curly hair. He's like at least 6'5", like 200 and some pounds, with a blue or black jumpsuit on. I think.
Okay. Let the court note for the record that the witness in this case has identified the defendant, Roderick John.
Noted.
Okay. And the state has no further questions for this witness, subject to redirect.
Cross.
Good morning, Officer Marshall.
Good morning.
My name is Attorney Lang. I represent Mr. Jung. I'm just going to ask you some questions of my own and then also follow up on some of the questions that ADA Pennington asked you. To start, I want to talk about this video footage. Did the video footage cover multiple different angles or was it one angle?
It covered multiple different angles, but the angle that I observed and the officer observed was Mr. Jung going to the door. Going to Mr. Ellington's door, banging on the door, then the door opening up, and him entering.
Okay, and so were you able to view this interaction from multiple angles, or was there only one camera angle that captured this?
Yeah, it was one angle that captured that directly, but Mr. Ellington notated that was his room door that Mr. Jung entered.
Did you verify that, or did you identify the room that was shown in the video and then go seek that room out for yourself?
We did not.
When you were viewing this, did you have a body-worn camera activated?
Yes.
Do you know whether or not the footage was recorded on your body-worn camera?
I can't recall.
But the entirety of the time you were present at the Welcome House for this incident, your body-worn camera was activated?
Yes.
Okay. I'm a little confused and I want to follow up. Initially, you said that the video footage showed him just walking through the door while reaching for his waistband.
Well, he was banging on the door, trying to get someone to answer. And then when the door opened up, he reached for his waistband and then barged inside.
Okay.
So, yeah.
A little bit after that, you said you were able to see the alleged firearm on the video.
Yeah, so it appeared to be the firearm when he was reached for his waistband. I didn't get like the full view of the firearm, but because he entered the door
So what were you able to see?
So I saw his hand go to his waistline and something appeared out. It was black and you could see what appeared to be the handle of a firearm.
Okay, so you saw him pull out a black object with a handle.
Yes.
Okay. Did the video footage have audio capabilities?
No.
Okay. Was it in grayscale or was it in color?
It appeared to be in color.
Did you at any point sit down with Mr. Jung and attempt to discuss his side of events?
No, because after he was detained, he was read his rights and no other questions were asked after that.
Okay. Are you aware of whether any of the staff of the Welcome House attempted to discuss these actions with him prior to calling police?
I'm not aware of any interaction prior to that.
So your presence at this incident and your eventual arrest of Mr. Jung was based off of the statements of Mr. Ellington and the other witness?
Yes, and the video footage.
But at no point was he asked about his side of events?
No, not after he was Mirandized and in custody.
No further questions at this time, Your Honor.
Any follow-up, Mr. Pennington?
No, Your Honor.
May
The
this
witness-
officer be excused.
Yes, Your Honor, I have nothing further.
Yeah,
Thank you, officer. Stay safe out there.
thank you.
Thank you.
All right, argument?
Your Honor, prior to argument, may I have a moment to discuss with my client?
Sure. Thank you. Which case are you doing? Which case are you doing? McLeod?
Yes, Your Honor.
Gotcha, okay. You can come on up and get comfortable if you want to. You can come on up and get comfortable if you want to. Sure.
Your Honor, there's not going to be argument. We're going to submit to the evidence testified to by the officer. However, we would like the court to address bond if possible.
Sure, all right. 119 days without indictment. Wow.
The defendant has 12 cycles. The defendant's last arrest was June the 22nd, 2016 in Fulton County, where a failure to appear. Those underlying charges were aggravated assault and criminal trespassing and battery. The defendant received a felony conviction in 2016 for aggravated assault. And the defendant, that case was sealed May the 5th. No, I'm sorry, I'm talking about another case. I apologize, Your Honor. The defendant received first offender in 2006 out of DeKalb County for aggravated stalking. That case was sealed May the 5th, 2009. The defendant does have misdemeanor sentences. The defendant received a nolo contendere sentence in 2011 for criminal trespassing and possession of marijuana less than an ounce, and one in 2005 for battery. Nothing in addition, Your Honor.
Mr. Lang?
Yes, Your Honor. Mr. Jung is 41 years old. He has his high school education. He currently collects SSI due to several mental health diagnoses. He's lived in Georgia for the last 26 years. He was raised in Mississippi, and then moved here when he was 13. The address on file is a good address for him. He lives at that address alone. The primary issue in this case, Your Honor, is we do believe there are some MH issues at play. I've spoken with Mr. Jung about those. He understands that our primary focus right now is finding some form of treatment or something to help get him back on the right track, get back on medication, things to that effect. The bond as it is right now is restricted to the point where I would not be able to get a program to assist him in paying that bond to get out to any mental health treatment that I was able to get him into. So based on that information, I believe it's currently set at $30,000. I would ask the court to consider lowering the bond to $10,000. I believe that'll still be at a point where it's financially restrictive for Mr. Jung, but it will make it much easier for me to get it paid once I get him into some form of mental health treatment.
So he's going to live at the 3034 Memorial?
That is correct.
All right. Mr. Pennington?
Yes, Your Honor, just give me a minute. I want to confirm what the current bond is. Might have had the wrong one.
Sorry, it's a $30,000 good bond set by a brilliant judge.
Oh, I got you. Okay. So it appears that the $30,000 bond was set just a couple of weeks ago on November 29th. I don't think anything today. There's been no evidence today which suggests that that bond should be reduced. So given the defendant's criminal history, the state would oppose a reduction in bond.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 234 Memorial Drive, and I think it's called the Welcome House in Atlanta, Georgia. We have a 24-hour curfew except for court, lawyer, medical appointments, and any mental health treatments or participating in any program that Mr. Lang may get you into. We have a $20,000 good bond. That ankle monitor will be paid for by the ORCA project. Best of luck to you, sir. And next is Mark McLeod, position 1. You didn't give me a brilliant embryo. Are you coming by Friday? You coming by tomorrow upstairs? You weren't? Oh, okay. Look at what I said. Look at your thing. We good?
Yes, Your Honor.
Okay.
That's Mr. McLeod Senior. I was just letting him know what
okay.
was happening.
Thank you. Thank you, sir. This is 22 CP 211539, Mark Joseph McLeod, It's like 119 days without indictment. There's a $55,000 good bond on aggravated assault, possession of a firearm during the commission of certain felonies. Go ahead, Sarge.
Swear affirm the testimony you should give to the court will be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Have a seat. Swear answer the rest.
Detective Henry Smith, Henry, last name Smith, Smith.
Good, strong voice. You can hear that, right, Madam Court Reporter? Go ahead.
Yes, ma'am. Thank you.
Good morning, Detective Smith. Where are you employed?
City of East Point Police Department.
Okay. And how long have you been employed there?
10 years prior, just came back in June of this year. So recently, about 7 months.
Okay. And were you working in that capacity? What capacity do you work for at the East Point Police Department?
Currently, I'm assigned to the Criminal Investigations Division, CID.
Okay, as a police officer?
Detective, yes.
Is that police detective? Okay, thank you. And were you working in that capacity on August 9th, 2022?
Yes, sir. I've just been reassigned to that division.
Okay. And are you aware of Mr. Mark McLeod?
Yes, sir, I am.
How did you become aware of Mr. Mark McLeod?
I was assigned this case a few days after this incident. Assigned by Sergeant Mashad, who was my supervisor. This case was presented to me by my supervisor, came to knowledge of Mr. McLeod by the events that happened on August the 9th at 1790 East Woodbury Avenue, the city of East Point, Georgia. That event was a shooting that took place at the public storage between Mr. McLeod and the victim, Miss Kenesha Rogers.
Okay. And so once you took this over, what did your investigation involve?
Yes, sir. I was provided surveillance footage of the actual incident and the actual shooting. Upon observing the evidence or the surveillance footage that was provided, it showed that Mr. McLeod and Miss Rogers had some form of a verbal altercation. A handgun was produced where Miss Rogers was shot, I believe, 4 times.
And who produced this handgun?
Mr. McLeod.
Okay. And did you say that Miss Rogers was shot or shot at?
She was shot.
She was shot.
Yes, sir.
Okay. Do you know what the nature of her injuries were?
Upon speaking with her while she was in the hospital, she was shot in the abdomen, I believe in the arm. I can't recall the other 2 places that she was shot. She stated that she had to have some of her intestine removed and that she'd had trouble passing bowel movements.
Okay. Thank you. So did you learn in your investigation what led up to this incident?
Yes, sir. Miss Rogers advised me that she went to the storage unit to retrieve some items from her actual storage unit. She saw a black male that she'd never seen before. She became suspicious of his being at the storage unit. She went to the front to tell the manager of the storage unit what she saw. When she relocated to the front of the storage unit, Mr. McLeod was coming around the corner. While Miss Rogers was conversing with the manager, telling her about her findings and just pretty much letting her know that this person was suspicious to her, they had a verbal altercation where Mr. McLeod, per interviewing him, stated that he had every right to be at the unit just as much as she did. As he was leaving, Miss Rogers relocated her vehicle back in the gate. Also, in interviewing Mr. McLeod, he stated that she almost hit him with the car. The video shows that Miss Rogers was pulling in as Mr. McLeod was walking out. They had another verbal interaction as Mr. McLeod was leaving. The video also shows that Mr. McLeod made it almost to the street. He was probably about 3 to 5 feet away from the street and pretty much gone from the property, and then came back. Miss Rogers went back into her car to grab a bag. Mr. McLeod stated that Miss Rogers pointed a handgun at him. The video does not indicate or show any handgun being produced by Miss Rogers. Mr. McLeod stated that he felt threatened by the bag, saying that, "What you got in that bag? What you got in that bag?" And he said that she produced a handgun. Shortly thereafter, shots were fired. Well, Mr. McLeod came back about 3 to 5 feet in the area of Miss Rogers, tried to grab the bag, and shortly after that, he fired multiple shots in the direction of Miss Rogers, striking her in the abdomen, and then he walks away. There was a witness also there, Miss Baker, Leah Baker. She was the manager of the public storage. And after that, East Point Police Department was called. CID was notified. Everybody responded. Miss Rogers was taken to the hospital for treatment by Miss Baker. And we followed up with her later on that day. And then Mr. McLeod actually called a couple days later he wanted to come in and talk to us and tell his side of the story. And that's where we interviewed him, and he was Mirandized, and spoke with him, and he pretty much explained that it was self-defense.
And so you determined, so did you issue these warrants for arrest after you spoke to the defendant, Mr. McLeod?
Yes, sir, we did.
Okay. So he explained that he believed it was self-defense. You've made warrants for aggravated assault. Why did you believe it was aggravated assault as opposed to self-defense?
Well, the video indicated that Mr. McLeod had every attempt to leave the property. He had multiple time to leave. He actually, like I said, he was about 3 to 5 feet away from the property, and the video will show that. And he came all the way back, maybe 20, 25 feet back in the area of Miss Rogers, where he fired his weapon at her.
Okay.
So that doesn't indicate any self-defense when he had every opportunity to leave the scene.
And the video, you stated, let me just make sure I have this correct, that you never saw a firearm produced on the video by Miss Rogers.
No video, okay. No weapon. When the search warrant was conducted for Miss Rogers' vehicle, the weapon was actually found inside of her bag.
Okay. And you said there was a witness at the scene as well, the manager. Were you able to learn any information from the manager?
I was not able to interview her. Detectives prior to interviewed Miss Baker and got that information from her.
And what did they learn?
That there was just an altercation. She was too afraid to really talk. But she just stated that there was a verbal altercation and that Mr. McLeod shot Miss Rogers.
Okay. And you mentioned that Miss Rogers was shot. Was there any other, anyone else shot, or was there any property damage or anything else that happened as a result of this shooting?
No, sir. Nobody else shot.
Additionally, I wanted to ask you here, in this case, so this location that you mentioned, is that in Fulton County?
Yes, sir, it is.
Okay. And during the course of your investigation, were you post-certified?
Yes, sir, I was.
Okay. And were you ever able to recover the firearm that Mr. McLeod use?
Yes, sir. He actually bought it the day he was interviewed by us.
Okay, thank you. And were you able to recover any shell casings or any other evidence of the shooting?
I believe detectives on scene recovered some shell casings, and those were submitted to, I believe, the ATF for NIBIN's cross-referencing.
Okay, and have you gotten any results back from that?
I believe there were some results that got back. Let me check my notes. Yeah. 4 shell casings were collected from the scene. They were submitted to, actually, I believe they were submitted to the GBI. So yeah, 4 shell cases were recovered.
Okay, thank you.
Mhm.
Do you see Mr. McLeod, Mark McLeod, in court today? You can stand up if you need to.
Everybody remove their mask, please.
Oh, yes, sir, I do. He's the black gentleman with locks, beard. He's wearing a blue and colored jumpsuit suit with a white t-shirt.
Okay. Thank you. No further questions for this witness, subject to redirect.
Records reflecting he's identified
Yes.
Mr. McLeod. It's okay. Go ahead, Mr. Lang.
Good morning, Detective Smith.
Good morning, Counsel.
My name is Attorney Lang. I represent Mr. McLeod. I'm going to ask you some questions. I'm also going to follow up on some of the things you said in response to questions from Mr. Pennington.
Yes, sir.
I want to start with, in preparation and your entire work on this case, did you review the narrative reports of any other officers?
Yes, sir, I did.
Did you review the reports of Officer Blaylock and Officer Mashad?
Yes, sir, I did.
Okay. And are you familiar today with the contents of those documents?
Pretty much so. Yes, I am.
Okay. So I want to talk about kind of what happened that day through the words of the eyewitness and the words of the officers who responded on scene. Are you familiar with the statement that Miss Baker initially gave to officers on scene regarding the operation of Miss Rogers' vehicle?
Say that one more time, Counsel. I'm sorry.
Are you familiar with the statement Miss Baker made to the officers about how Miss Rogers was operating her vehicle?
No, I was in interviewing Mr. McLeod. He stated that she almost hit him with her car.
And are you aware that Miss Baker gave the same accounting to Officer Blaylock in her initial interview with Mr. Blaylock?
No, sir, I'm not familiar with that.
She gave a statement stating that Miss Baker re-entered her vehicle, drove towards Mr. McLeod, and stopped right in front of him as he was driving out. It was almost as though she was about to hit him while he was exiting.
Mm-hmm.
So you're aware that she gave that statement to officers?
Yes, I am.
Okay. And are you aware that she gave the statement to officers that when this happened, Mr. McLeod was still within the gate of the property? He had not left the actual gating of the property at that time?
Yes.
Okay. You stated that at a later date, the firearm was recovered inside of the bag in Miss Rogers' car, correct?
Yes, sir.
That is the same bag that Mr. McLeod told you Miss Rogers raised towards him. She went into her vehicle to pull out that bag and raise it towards him.
Correct.
And it was that bag that a firearm was found in.
Yes.
Mr. McLeod told you that the reason he would have produced a firearm was because the victim in this case was attempting to shoot at him with a firearm.
Correct.
Which was later recovered in that bag.
Correct.
Okay. Did you at any point come across any information that stated that Mr. McLeod did not have a legal purpose for being on that premises?
No, sir, I did not.
Okay. And again, just the way you framed it during direct, you're aware that so Miss Baker and Miss Roger were having a conversation at the, I guess, leasing office or whatever the name for it would be within the storage facility, kind of the managerial office.
Yes.
And Mr. McLeod eventually overheard a portion of that conversation.
Yes, sir.
There was a verbal altercation.
Yes.
And after that, Mr. McLeod attempted to remove himself from the property.
Yes.
It was while he was attempting to remove himself from the property that Miss Rogers actually blocked him off with her vehicle to stop him from exiting the property and reinitiated the verbal argument.
No.
That's not the statement that she gave to officers.
That's not what the video showed. I'm sorry.
Okay, but that is the statement that the eyewitness gave to officers on the scene. And that lines up with what Mr. McLeod told you about the events of that day.
Mm-hmm.
Okay, The shell casings that were recovered, you said that they were tested, correct? They were given to GBI?
Yes, sir.
Have you received any of the results of that testing?
I have not, no, sir.
Okay. Do you know the caliber of the 4 shell casings that were recovered?
Believe they were 9mm.
Were all 4 9mm?
Let me check my notes. Yes, sir.
And I know I just asked this, I didn't write it down. You said you have not received the results of any testing from those yet, right?
No, sir.
Okay. Again, sorry to make you repeat yourself. Just to make sure I understand, you did not reach out to Mr. McLeod and then he came to you. He reached out to you to come and give you his side of events, correct?
Yes, sir, he did.
And he brought the firearm involved in this incident.
Yes, sir, he did.
Did you direct him to do that or did he do that of his own volition?
He's actually spoke to Detective Armand. That recording was provided to me about him wanting to come and talk. I don't recall the exact wording that he used, but he did bring the weapon in.
Okay. Did you run a criminal background check on either Mr. McLeod or Ms. Rogers?
Mr. McLeod, I did. Yes,
okay. Since there was an allegation of, I guess, hostility or violence from both parties, did you run one on Ms. Rogers as well?
I did not. No, sir.
Okay. One moment, Your Honor. Are you familiar with the statements that Ms. Baker told officers she overheard during the second portion of the verbal altercation?
No, sir, I'm not.
Are you familiar with a statement Ms. Baker made stating that she heard Mr. McLeod say, "I have a gun too"?
Yes, sir, I do recall.
Okay. And that Ms. Baker took that to understand that Ms. Rogers therefore had a gun as well?
Yes, sir.
Okay. At this time, I have no further questions, Your Honor. Ready to proceed to argument.
All right. Redirect.
Yes, Your Honor, just give me 1 minute. Your what was your testimony as to, just let me just be clear of who said I have a gun too?
Mr. McLeod stated that.
Okay. No further questions, Your Honor.
No recross.
This also be excused?
Yes, Your Honor.
All right. Thank you, Austin. Good to see you again.
You too.
All right, stay safe out there.
Yes, ma'am.
All right, argument?
Yes, Your Honor. I'm going to be asking the court to dismiss this count primarily because there's a relatively strong self-defense argument in this case. Specifically looking at the details provided, there's an eyewitness who is able to testify that the victim in this case blocked off my client with her vehicle while he was attempting to remove himself from the situation. We don't know what specifically was said during the verbal altercation, but there was enough that my client knew that the victim had a firearm in her bag. She went back to her vehicle during the verbal altercation to grab that bag and raise that bag in his direction, where it is then alleged that he took actions that are the basis of this aggravated assault charge. That is the very foundation of a self-defense argument. He knew she had a firearm. She was going for the firearm. She raised the bag containing the firearm in his direction, and only at that point did the aggravated assault allegation occur, which would be the very textbook definition of self-defense, acting in defense of himself. The main argument here is, again, the fact that he was in the process of removing himself from the situation. He was in the process of going away. She cut him off. She blocked his path of entry and re-engaged, therefore becoming the aggressor of that second incident. Based on that information alone, I'm asking the court to dismiss, as there's a very strong and understandable self-defense argument in this case. If Your Honor disagrees, we would ask to be heard on bond based on the same.
Mr. Pennington.
Yes, Your Honor. In this case, the detective testified that the defendant was not blocked from getting out, that he had space to leave. The defendant, the victim in this case, there's no evidence the victim in this case actually produced a firearm. We do know the victim had a firearm, but the victim, the video evidence, the officer was able to review, and no firearm was ever produced. Your Honor, in this case, the state submits on the evidence that the charges as charged in the warrants are valid and that probable cause should be found. The state would also note in this case that based on the testimony of Detective Smith, that it appears that there may be an aggravated battery as well. The state at this point, until it gets more information, will just ask the court to add a battery in this case.
All right. Anything else?
Your Honor, I would just again go to, we were not shown this video footage today that contradicts the eyewitness's statement. What we have is testimony that an eyewitness gave the accounting of events that leads to the self-defense argument at this time. The primary question would be, how did my client know the victim had a gun in her purse? That to me is the crux of this. How did he know she had a gun unless he was somehow made to know she had a firearm?
All right. I'll go ahead and find probable cause in both counts. We can be heard on evidence. It's a $55,000 good bond as of November the 29th. Wow.
Your Honor, the defendant does not have any prior arrests unfound. Nothing in addition.
All right. Go ahead, Mr. Lang.
Yes, Your Honor. First and foremost, for the IALA factors, give me 1 second, Your Honor. I have the wrong sheet in front of me. My client is 26 years old. He's lived in Georgia for the last 5 years of his life. He lives at the Sandtown Road address that I believe is not listed on his booking report, so let me make sure it's read out just in case. 1671 Sandtown Road, Southwest Atlanta, Georgia. He lives there with family members as well as a family friend. He does not have any children. He has graduated from Hillsborough Community College in 2015 with his associate's degree in computer science. He has a certificate in digital media from Omnitech, which he got in 2019. He currently works in a private contracting construction business. Looking at the information presented, based on the fact that he has no criminal history, I asked the officer about it during the prelim. He was unaware of it. There is a history with the victim here having been convicted of pointing a firearm at another person, which again gives rise to part of the self-defense argument in this case. Based on the strength of the self-defense argument in this case at this time, and the fact that his father is present here in court, been in repeated contact with his father, one of his strongest advocates at this time, I am asking the court to drastically lower this bond. I would ask the court to consider $5,000 on each charge. If the court is willing to hear it, Mr. McLeod Sr. did want to offer a character statement to the court.
You can come on up, Mr. McLeod, if you'd like. You mind swearing him in, Mr. Lang?
Yes, sir. Please raise your right hand. Do you swear or affirm any testimony you provide to this court will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay.
Thank you.
Go ahead and tell the judge what you'd like her to know about.
Morning,
yourself.
Mr. Lang. Go ahead.
Good morning, ma'am.
I mean, Mr. McLeod. And you, Mr. Lang, too, both of you.
Well, we're standing next to each other,
Right.
so it works out. So I just wanted to make the court aware, and Your Honor, aware that Mark doesn't have a violent bone in his body. He's never been in any type of like physical, threatening altercation before. We are a law enforcement and military family,
Wait, what military first?
both Navy and Army.
Okay, you got me on Army. The Navy wasn't persuaded by the Navy
So
because of the Army.
his grandmother is a retired lieutenant colonel.
Oh, yes, ma'am. Yes,
And-
ma'am. Yes, ma'am.
Yes, ma'am. And his father was a Navy officer and a police officer for 25 years for the city of Newark, New Jersey.
Okay.
I wear the badge on my neck. I have it on under my shirt. He has a support system. He's got family. He's got pretty much everything he needs to be able to be pulled out of this situation until these trials happen. I drove here from Pennsylvania for the purpose of requesting whatever you can do to help him get out of here. I want to take him away from Georgia. I don't want him to stay in Georgia because the victim is out and we don't know what her intentions are as far as revenge or whatever. And I would just want to make sure that he's safe. so that he cannot have to engage her or be dealt with in whatever way she, deems necessary. And with that, if you could, find it in your heart to just at least let him be able to get out of here so that I can take him up. We will provide the district attorney and a prosecutor with whatever address he's going to remain at, but we want to get him out of Georgia until it's time for him to come to have his day in court. He would be no threat to anyone.
Mr. Pennington?
Yes, the state will have concerns about the defendant leaving the jurisdiction, but let me just ask if the witness, so my understanding is that he would live with you, is that correct? Or
Going to live with his sister.
his sister, okay. Do you know if there are any firearms in his sister's home?
No, she's not a fire advocate and she has children. So his nephews will be there with.
Okay, all right. No further questions.
So he's going to be Pennsylvania?
He will actually go to Indiana.
Indiana, okay.
Yes, ma'am.
All right,
Yeah, no further questions for the witness.
all right.
And as Mr. McLeod stated, I'll also make sure that a change of address is filed once we get the address of where he's going to be in Indiana.
All right, I know before that I put ankle monitors. They work up there, right? He's going to keep it charged?
I've had one client who moved to North Carolina while still on the monitor, and from what I understand, she hasn't had any issues. The only issue would be, just to make sure that you guys know, if the charger breaks or the ankle monitor itself breaks, someone would have to come back to Atlanta to get it repaired.
Understood.
But because I don't have locations anywhere else, but someone would have to come back here to get a new charger or a new device. But I believe they can still monitor anywhere in the country.
Yeah, I think so, because it's GPS or
Yeah.
whatever it is. Mr. Pennington?
Yes, just as far as our bond argument goes, the state would oppose the defendant leaving the jurisdiction. We do understand this might be a good situation, but the state would just have concerns about the defendant reappearing in court. The state is concerned at this incident, although this defendant does not have a violent history. These are multiple shots fired, and we do have an injured victim. We'd also note in this case that it does appear very likely that a charge for aggravated battery will eventually be added at indictment based on the testimony we heard from the detective today. So, Your Honor, taking all that into account, the state would just ask for a bond in the court's discretion. We understand the state does note that bond was just heard a couple weeks ago, but Your Honor has heard evidence today, and that may influence whether you wish to amend the bond or not. The state does think the current bond is appropriate. The state would ask for whatever conditions the court deems appropriate, but especially in this case, no further contact with the victim, no weapons, and then 24-hour curfew with an ankle monitor.
So, Mr. Penning, do you think, I didn't hear anything with failure to appear. So,
I was going to say, Your Honor, if I could add one thing additionally, he turned himself in this case, and not just turned himself in, brought what to the state would be one of the most important pieces of evidence in this case along with him voluntarily. That shows complete deference to the court and a complete willingness to submit himself to the court whenever needed.
I'm just asking if you got, and Mr. McLeod, forgive me. So if you got the victim, and you spoke to her enough to say, hey, if this guy is not in the state of Georgia, would you feel better? I didn't hear anything with failure to appear. He's got an ankle monitor on him.
The state just has an experience of once just defendants leaves the jurisdiction, it can be very difficult to get the case, get them back into the jurisdiction.
Yes, sir.
Can I vouch that I will make sure personally that he is back in court? I work for the government right now, and we're not liars. We're not bad people. We're a good family. He will be in court on the court date. I'm telling you that to your face, sir.
What government do you work for, Mr. McLeod?
I'm working with the Department of Defense Information Systems Agency. I'm a division chief over cybersecurity. I defend our network.
Information systems. Put him to work to fix the network here.
Everything's down upstairs. I'm like, wait a minute, what? But
everything was down here the other
Last
day.
2 days, our network's been.
It was down bad here.
Yeah.
So, Mr. Lang, you got to give Mr. Lang your phone number, because when we have issues with the internet at night here in the county, we got to go.
Actually, I was going to say, I don't need it. I've been emailing and calling you. And I was going to have you write it down, but.
So, it's not like I have it. I'll amend my bond order. What do I got here today? Ms. Holmes, I'll amend my bond order with the 24-hour curfew except for court, lawyer, medical. Is he going to have employment there?
I'm not aware, but his sister did say that she was going to get him a job. But if, like, let's do this. If he has to come stay with me in Pennsylvania, I'm fine with that too. And then that way I can make sure he has employment and then you can get more of a guarantee that he'll be in court. We were just trying to give him the best situation, for him.
Yeah, I mean, if he has to stay with you, either way, I'm just asking, Mr.
As far
Lang.
as the employment goes, Your Honor, I think for now, if Your Honor wants to put what you sometimes do on the ORCA calendar of employment, but we need the schedule and stuff like that. That way he has, so he can go on job interviews and things like that. And then once he gets a position, we'll be in contact. I'll get a copy of the schedule, provide it to Your Honor and ADA Pennington, and we can amend the bond order to specifically cite that work employment.
All right, so it'll be court, medical, and employment to include searching for a job. And when he gets a job, we'll amend the order to include who he's working for. So saying that, he'll have to imply proof of employment, the name of his employer, schedule, the exact location he'll be working. And with this ankle monitor, it's paid for through the ORCA. We have this ORCA project to work with the backlog, and they're financing some of the ankle monitors, non-taxpayer money, but this. So what we want is you're going to get it on, sir. You cannot let this thing go dead. You have to keep it charged. Don't get it wet. There was another thing that Sheriff Labat was checking on, but I'm not sure that could be paid through ORCA on the watch.
Yeah, I've heard like rumblings about it, but I don't think it's anywhere in the system yet.
Yeah, so it'll be this, all right? So it'll be your 24-hour curfew. Now, if you're going to live with your dad, you follow the rules of your his dad, right?
Yes, ma'am.
You go follow the rules of his house. If your dad says, take out the garbage, you take out the garbage. Because when you go back and you live with the parents, you're still a kid. Take out the trash, be in at a certain time. You got to do all that, all right? You got to stay away from all extra space storage facilities and stay away from 1790 East Woodbury Avenue. No drugs unless prescribed, no alcohol, no weapons. 24-hour curfew except for those medical appointments, attorney visits. Like I said, you can apply for a company, and once you get a job, you have to provide proof of employment. Also, no further contact with Kanesha, Kannesha Rogers, and also Aaliyah it says Liyaah Baker, Baker. And let's see if I get this right address, 1790 East. Trying to read my handwriting. Now, sir, he can't be around weapons. So,
Yes, ma'am. Well, I don't allow him to have that in the house.
okay. So if you have weapons in the house, unfortunately, he can't be around any weapons. So, anything that you need him to do specifically that you need me to put in here?
Stay out of trouble.
That's given. Stay out of trouble. All right. All right. So we'll reduce it to 30,000 and we'll leave it at 5,000. So 35,000. It's like $3,500 with a bonding company.
And we'll talk a little bit more about that in a little
We're
bit.
missing a party over here next door. Y'all
Sounds
like.
like,
All right. So you just go through, I don't know if you're staying and you're going to be able to make that bond for him, but it'll probably be,
We'll discuss it. Your Honor.
late, go to your hotel, go have dinner, go have lunch, then wait. And then it'd be later tonight by the time you'd be able to get him out. Okay. And they'll put that ankle monitor on you. Best of luck to you, sir. If anything happens, breaks his leg, has to go to the hospital, let Mr. Lang know because they have to get permission to remove the ankle monitor and place one back on, et cetera. Okay.
Yes, ma'am.
All right. Best of luck to you.
thank you for showing up today. I'm sure it made a difference.
Was that the last officer we have present? I can't see.
Oh, we do, that is the last officer we have present, but we do expect one officer to show up for sure.
I'm gonna ask, can we take 5 so I can go
Sure.
discuss? with
Yeah,
him?
yeah.
Thank you for showing up, sir.
And I'd like to meet him
And-
all.
And tell the Lieutenant Colonel I said thank you for his service.
All right, so I'm gonna talk to Dad and I'm gonna figure out what we do from here, go back and listen to everything.
So we'll
he says.
stand down here for a second because
gonna go try to make a call on at least one of these cases.
he's going to try to get in touch with the officer. So we'll stand down here for a second.
So. Yeah, Bradbury.
That's how I feel. Hey, then you didn't explain it. I'm okay.
Let me grab this file.
So I've got one officer who says he'll be here in 30 minutes. There's some miscommunication, I think, with this officer. So I told him to go ahead and come on unless you have a reason why you don't want to wait.
So is the officer on which one?
That is on Bradbury, which is position number 6. Yeah. For 7 and 8, we have no updates. So we don't have any expectation the witnesses will show today. We've left messages, et cetera. And that is one where, that we'll hear bond on that. So I would expect. So we can take that up. If you wanted to reset 6, I could tell the officer to stand down, but if he's saying he can be here in half an hour, that seems reasonable.
I can pull them out for you. Oh, he's in there? I mean, he's in there, we can wait till everybody else. Okay. So, did you put them in the night queue?
Judge, did you say something to me?
You put them in the night queue for me, right?
Yes. Did you turn your mic off? Because I barely can hear you.
I did turn it off. Thank you, Miss Holmes. Well, because I was talking on the phone to the office.
You're welcome.
Thank you. Ms. Jackson, you here with us tonight, or is it going to be Boston?
I think it's gonna be Bostic, Your Honor.
It's a long night tonight. It's like 30 some odd positions. Now you're like, it is going to be Bostic. Yeah.
Are we recording?
It's for me, the court reporter.
Okay, so we are recording. Okay, that's fine.
I mean, she stopped recording.
No, it's fine. I was just going to chat, but it's not.
Okay, you stop the recording, Madam Court Reporter, for a second.
Yeah, well,
It is what I-
yeah, we go. It's not a big deal.
My name's here.
Sorry about that.
No, that's okay. I'm sorry. So, hang on. So gonna address the bond, and right, that's. what it is.
I think your mic is off, Judge.
All right, so in position 5, we were talking about that before we started. What are we gonna do there?
So Your Honor, the defense would have a motion in this case. I understand Your Honor, may already have an idea of what's going on, but the defense would move to dismiss this case for want of prosecution, this being the second time the officer has been unable to appear for court. I understand that both times there have been a reason. I believe the first time he was on pre-approved leave, and now this time there's a conflicting subpoena. There are other officers involved in this case who could have been subpoenaed. My client has been in custody for over 100 days at this point, waiting for this court date. He's already been reset once, told that we're going to give the state another chance to get an officer here. This is the another chance. There's still no officer here. So I'm asking the court to dismiss, allow my client to be released.
Your Honor, the officer has a conflicting subpoena in this case. The state submits that's a valid reason for this case to be reset. We do understand that this defendant, though, has been in custody for over 90 days, and that reconsidering the bond would be appropriate in this case. So the state's prepared to go forward with a bond hearing.
This is true. He was down in Jackson
Yes,
on a.
Jackson, Georgia,
Yeah, Jackson, Georgia for
probation.
revocation hearing, Mr. Lang.
And again, Your Honor, I completely understand that. It's the argument that because this is the second time, even if there is a legal reason, what happens when next time there's also a legal reason, and all of a sudden Mr. Dunges has been sitting here for 5, 6, 7 different court dates waiting to get in front of a judge because the officer keeps having some kind of reason why he can't be here.
All right, well, since he's there, he said it was 9 o'clock this morning, but I guess that still takes a few minutes to get here. So we'll just have to make this I don't know, can we special set this? That'll trump anything else he may have?
The state will advise the officer. I'll personally call the officer and let him know that whatever reset date we have.
Yeah, because I don't know, I think this hearing would have trumped, was it a state court hearing that he's in?
It's a probation revocation hearing.
All right, yeah, you need to talk to him. This will be the absolute last reset. He's got to get here. If he has to appear by Zoom because he's somewhere else, he's got to make, like when I was a cop, if you were going to make the case, you need to show up at all the hearings, but that was a few days ago.
Yes. I would say, Your Honor, just for clarification, the calendars say that testifying witnesses will need to appear in court. If it is possible in the future for testifying witnesses to appear on Zoom.
I'll usually look at it by a case-to-case
Okay.
basis. Office policy is to not allow witnesses to, but in this case, if it gets Mr. Dungy's day in court, we'd.
Okay, well, that's something the state will take into consideration for the
For this
future.
officer specifically, if we can get him over Zoom, we'll allow it over Zoom.
Okay.
Just to get
Thank
it
you.
done.
Thank you.
Right. I mean, for him, you can have him here. He can appear by, things happen. Life happens. So if there's one officer that has to appear by Zoom, that's fine. Like if there's a lawyer that's somewhere else that has to appear by, as long as they don't appear in their car driving.
Before we have the bond hearing, I just wanted to ask pretrial if this defendant is eligible for pretrial.
Pretrial is position 522 CP 212020 eligible for a pretrial release.
I'm not seeing any felony convictions, but I will double check. Let me go ahead and give you the history and see what that recommendation was, Your Honor.
Okay.
The defendant does have 8 cycles. The last arrest was October the 3rd, 2020 in Coweta County, Georgia, for driving while license suspended or revoked. The defendant does appear to have an outstanding hold out of Noonan, Georgia, for a failure to appear. The date on that warrant was March the 8th, 2022. I do see what the defendant did receive a misdemeanor sentence, a nolo contendory sentence in 2021 for driving while license suspended or revoked. And if you could hold for just a moment, let me just check and see what our recommendation was for him, please.
Your Honor, could I also just make a request? If we're going to do his bond hearing now, can we bring him out?
Sure. Yeah, absolutely. You can bring out position 5.
Okay, he was not recommended because of the outstanding hold that I just announced, Your Honor.
Okay.
It's your courtroom. Nothing in addition.
I got you.
Do we know what the underlying was for that outstanding hold?
Do we know what that charge is for that hold?
It's not listed in the GCIC, Your Honor.
Okay.
And I don't have any additional information.
All right, so this is 22 CP 212022. Jason, I think it's Donjeez. It is, what is it? Let's see. 104 days without indictment. You got BGCSA possession of Schedule 1 or 2, attempting to misrepresent a tag, no insurance, driving with suspended or revoked license, knowingly driving a motor vehicle and suspended, canceled, or revoked registration. There's a $3,500 good bond as of, I think, the 28th, 29th. Wow. You do that for the, so his client can hear that?
Is this for the same one that we just read off, Your Honor?
Yes, ma'am, but he's in here now.
Okay. The defendant has 8 cycles. The defendant's last arrest was October the 3rd, 2020 in Coweta County, Georgia, for driving while license suspended or revoked. The defendant does appear to have an outstanding hold in Noonan, Georgia, for a failure to appear. The date on that warrant is March the 8th, 2022. The defendant does have one misdemeanor sentence. That was in 2021. The defendant received a no contendere sentence for driving while license suspended or revoked. Nothing in addition, Your Honor.
All right. Go ahead, on a bond argument, and that bond was set, I'm sorry, September the 3rd.
Correct, Your Honor. Mr. Deniez is 44 years old. He's originally from Atlanta. He will live at the Sharpsburg address that I believe is not indicated on his booking report. So that address is 27 Border Point in Sharpsburg, Georgia, 30277. He lives there with his father and stepmother. He does not have any children. He is a high school graduate. He's a United States Navy veteran, having served from 2000 to 2022. He's currently, wasn't unemployed at the time of his arrest. Hopefully we'll be able to find him something in the future. I do have a note here saying that we believe that Coweta hold is a drug-related case, but I don't have any additional information on it. Looking at the bond that's currently set, it's $3,500, as Your Honor stated. He's had that bond for 3 months and been unable to afford it. Based on that reason, I am asking the court to consider setting UJRs across this case at pretrial, even if Your Honor wants to make it level 3 for the intensive reporting. Just releasing him on pretrial. Otherwise, I would ask the court to hold the felony count where it is and make all other counts UJRs, which I believe would lower the total bond to $1,500, which would be easier for me to get a program to pay or for Mr. Deniez to pay himself.
Mr. Pennington?
Yes, Your Honor, given the time the defendants spent in jail and the nature of the charges, the state would not oppose the UJR pretrial for the misdemeanors. The state would ask for a bond to remain on the felony charge.
Ms. Jackson? We are going back to in-person reporting.
No, we haven't, Your Honor.
All right. Let's see. Let me get this right. Okay, here we go. Let me go back over my conditions here. No drugs unless prescribed, no alcohol, no weapons, no driving without a valid license, insurance, registration. So we'll reduce, sorry, I'm trying to pull up the bond order. The misdemeanor, so it's 2, 3, 4, and 5. Can go through pretrial level.
Level 3.
Level 3. Random drug screens. He can stay out of Fulton County unless he's here for court, see his lawyer, or report to pretrial. Sir, don't go back to Fulton County. Fill up with gas in Coweta County. Drive to court, drive to pretrial, drive to Seamer's Lane. Fill up all the way, not $5. Fill up with the tank full, so you don't have to fill up again, okay? You can come back for pretrial, and if there's any other, you plan on getting him in sort of classes?
We're going to be working on it, yes, Your Honor.
Okay, and if there's any programs that Mr. Lane gets you into, if they happen to drift over into Fulton County, you can do that. You can have that ankle monitor with a 24-hour curfew except for work, lawyer, court, all of that, and the classes. That'll be paid for by the county. So stay out of Fulton County. And the only reason you can come back is for that. And those are the reasons you can leave your house. Court, lawyer, any kind of medical appointments, addiction appointments, or any program that Mr. Lane gets you into. We'll leave count 1 at $1,500. The other one will be UJR through pretrial level 3. You have to call pretrial within what, 24 hours of getting out?
Yes, Your Honor.
Okay, within 24 hours of getting out. If not, I'll be seeing you back in here. Best of luck to you.
Your Honor, do we want to have a reset date on this, or do we expect the defendant to bond out?
I would still ask for a reset date.
It's January.
We moved to January 17th.
But I just had said,
Okay.
told the court I would let the officer know, well, you know, so I
January-
just want to do that.
Is that 9 a.m.?
Yes.
9 a.m., January the 17th, last date for prelim.
Your Honor, I did not mean to interrupt, but are those charges misdemeanors? That you released them on a signature bond through?
Yeah, does it have to go through misdemeanor pretrial?
Well, Well, it's still pretrial. It's just no level. That's all I'm saying.
Well, still give him random screens.
Okay. that's
Thank
fine.
you.
And do I
you.
need to put per judge on here?
Yes.
Please, thank you.
Sure, and the consent of the state and the defense attorney. Consent of the state, that's important you get on there. That bus gets heavy all by myself. And when he gets finished, we'll talk about the last ones.
Right. Well, I think yes. Which,
Oh, because the other,
well, we have 3 outstanding, but 2, we have no expectations. So
Mr. Lang,
Yes, Your Honor.
on the Bradbury case, Mr. Pennington said an officer will be here, I guess it'll be like 20 minutes now. I guess he can reach out to that officer again. And the other 2, nada on Hill and Maltsberry. Nothing from any officer.
we have no updates on those. We would just request a reset in both cases. These are both serious cases. Your Honor, we would just request this to be reset for another date. We would expect to be able to subpoena the officers and have them appear by then.
It looks like both of them are over 90 days with no bond. Would you at least like to hear a bond hearing? Because this will be, I'll give 1 reset for officers.
Well, Your Honor, just to put on the record, the defense would have a motion in both cases.
Go ahead.
I'll start with position 7. We would move for a dismissal for warrant of prosecution based on the failure of the officer to appear for court or provide a legal reason as to their absence. We have other officers who called ADA Pennington and provided him with a reason why they're not in court today. This officer is a no call, no show. If this case is that important and that, upsetting, I guess, in the nature of the charges or that serious, then the officer should be here to do their diligence on the case. They're not. Based on that, I would ask for dismissal, and that would be the same argument on position 8, understanding Your Honor's, not just discretion. That's the word, discretion.
I know it's getting late. Mr. Pennington, would you like to respond to Mr. Lang's argument?
Yes, Your Honor. The state understands Mr. Lang's argument, but the state also has to consider that there was a victim in this case. So the state does request a reset here. But given the argument that Mr. Lang makes, it would be appropriate for the court to note in this calendar that the officer did not show.
Is it the same officer on both?
No, it's 2 separate officers.
Okay. Well, they've been in 94 days, one without an indictment, and I do believe they're both on no bond status. So, like I said, back in the day, when I was a cop, if you didn't show up and you were subpoenaed, you got 3 days off without pay.
Your Honor, our understanding from talking to APD is that they are, at least with the Atlanta Police Department, is that they are implementing without pay. I think it might be 2 days, but I'm not sure the details that for officers that do not show, and we will let the APD know of any officers that do not show.
Yeah, I mean, it's not fair to these folks that sit in jail. They still have that presumption of innocence, yet they're sitting in jail. And yeah, we can get them on a bond hearing, but they have that right to the prelim. And I don't know. Trust me, I get it. I was a cop. I'd stay up. I'd work all the time. And sometimes I'd fall asleep sitting in the courtroom, but and it's not you, but they got to get here. If you're going to put them in jail, then show up to court. It's simple. And I know that I will take you first. If you've been up all night, I'll take you first. Whatever it does, I will make an exception. But yeah, I hope so. If not, I'll talk to Chief Kirschenbaum myself and tell him to get these officers here. I mean, this is insane, truly insane, but it's not your fault. So we'll do that. One only reset. Ms. Holmes, 1 reset, period. And those are going to be the 17th also, Ms. Watts? So those will be the 17th also at 9 a.m. Both will be at 9 a.m. She's hiding over here under the bench, so you can't hear her because she's way up in front of me, like whispering. So those will be that also. And do you just want to go ahead and address bonds on 7 and 8?
Yes, Your Honor, but I do think my clients would need to be present for those.
Yeah. Okay. So we'll take Hill, Aisha Hill first. I've had a lot of cases today. I'm losing my voice all week. It's been a long week. No, but all those calendars and like blah, 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 blah. Yeah. All right, this is position 722 CP 212301, Aisha Hill. Hopefully I pronounced that correctly. One charge of aggravated assault. There's 94 days without indictment, and there is no bond as of today. Wow.
The defendant has 13 cycles. The defendant's last arrest was September the 5th, 2017, for a probation violation. The underlying charge was aggravated assault. The defendant does appear to be on probation in Fulton County for aggravated assault. That case number is 15 SC 137519. And that disposition date was February the 8th, 2017, and the term is for 8 years. Also, the defendant appeared to have an outstanding hold out of Troup County, Georgia, for a failure to appear. The date on that warrant is February the 27th, 2018. Nothing in addition, Your Honor.
And Mr. Lane, as of December the 12th, there isn't a sealed order, so I'm assuming that was an eval?
That is correct, Your Honor. That is something we are working on. I did speak with Ms. Cole, who's the attorney of record on this case. We have sought out some services as well with our own office. So at this time, I am still going to be requesting that a bond is set. So that once we get to where we need to get to in this case, we can work on bond. But my client is not going to be able to make any bond at this time. So I'm still asking that one be set just while we have a court date in front of Your Honor at this time.
You know where she'll be living?
Yes, she'll be living at the 257 Bromack Drive address listed on her booking report. And that address, she'll be living there with her aunt and several of her children.
Okay. Anything else you want to go ahead with some Ayala factors?
Yes, Your Honor. She's 44 years old, lives at the address I indicated. She has 7 children and 4 grandchildren. She made it to the 12th grade. At the time of her arrest, she was a full-time grandmother. She was the primary caregiver for all 4 of her grandchildren. However, she had also applied to and was supposed to be starting a position at a kinder care location where she would be working, taking care of children and working in that industry. Understanding her history, understanding what we've heard about Ayala, she's a lifelong resident of Atlanta. All of her family lives here, all of her children, all of her grandchildren. And understanding what Your Honor does about the order that's already, or the sealed order that is already in place, I would ask the court to consider a bond of, on a charge like this, I would ask for $20,000.
All right. Mr. Pennington.
Yes, Your Honor. The state would just like to note that the defendant has a criminal history that includes an ag assault here in Fulton County. Additionally, we'd just like to note the nature of this crime. The officer here at the scene found lots of blood. So the victim was bleeding from multiple places. So the nature of this violence here was severe. So the state just asked for a bond that reflects here that the defendant's likely to reoffend and the danger to the community that this defendant poses. And additionally, here in this case, the state would request no further contact with the victim, Kenyetta Young, Kennytta, Young, common spelling. no weapons, an ankle monitor, and a 24-hour curfew, and whatever other conditions the court deems appropriate.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 2763 Metropolitan Parkway. No further contact with Kenvetta or Kenyetta, Kennytta, Young, Young. I think I gave the address of Metropolitan Parkway. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, including any sort of mental health treatment. And you can also let Ms. Cole know that if there's a program that she gets into, we can definitely modify that to suit that. And you will have 48 hours to have that ankle monitor placed on your hold. So, Ms. Holmes, if the Troop County picks her up, she'll have 48 hours to have the ankle monitor placed back on her ankle for here. $30,000 good bond. Best of luck to you, ma'am. Also, did you get your hair cut yesterday?
Every day I gotta come to court. I'm tired. Got up 5 o'clock in the morning last night. I just found out I had court today, 10 minutes ago.
I got some clippers at the house. Come by there.
I need an overnight barber.
That's how I made extra money in law school. All they need is their head shaved, so it was real easy.
Your Honor, do we want to do this?
Yes.
Yeah, we'll go ahead and do yours. So we got
That's the officer for Bradbury.
Bradbury, right?
Correct.
Come on up.
Yeah, a traction truck almost took me out, but I got it.
Uh-oh. Well, it's raining. People can't drive when it's been raining.
Do you swear affirm the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
All right, wait on him to get out. This will be, and we're gonna address bond on this one too, because it's been 94 days.
Although I will say, Your Honor, if there's not already, this is a case where I anticipate a sealed order.
Okay. Yeah, and if you don't have one, then send me the motion in the order and I'll be glad.
I'm sorry, Judge. Did the officer state his name and spell it?
Oh, yeah, hold on. Raise your right hand. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right, state your name and spell it for the court reporter.
Officer Cunningham, it's gonna be Cunningham. I work for the City of Atlanta Police Department, Fulton County.
So there is, as of September, there is no bond on the 2 counts that wait. Okay, so it said that before there was a battery, but it was dismissed, yet it shows up on here. Was another battery added? Because at first appearance it had, oh no, sorry, it's no bond. All right, so there's no bond on the ones that are left. My bad. All right, Mr. Pennington, this is a 22 CP, yeah. 212-296, Damian Jamar Bradbury. There are 3 counts: false imprisonment, abuse, neglect, or exploitation of a disabled elderly person, and battery. Go ahead, Mr. Pennington.
Yes. Good morning, Officer Cunningham. Thanks for making it down here. You mentioned that you're employed with the Atlanta Police Department. How long have you been employed with the Atlanta Police Department?
6 years.
Okay. And in what capacity are you employed with the Atlanta Police Department?
Police officer.
Okay. And were you employed in that capacity on September 12th, 2022?
Yes, sir.
Were you post-certified on that date?
Yes, sir.
Okay. Did you become aware of a Damian Bradbury on that date?
Yes, sir.
How did you become aware of Damian Bradbury?
I was flagged down by concerned citizens saying that the elder man who owns the barbershop on my beat was getting robbed. The people were frantic. Upon my arrival, I went as fast as I could, got to the barbershop. The door was locked. I attempted to make entry. Mr. Bradbury wouldn't let me in. Eventually, he unlocked the door, so I was able to force my way in. And that's when we took him into custody.
Okay. What did you see when you entered?
He was covered in blood. The victim had sustained several injuries due to an assault.
What were the nature of these injuries?
Lacerations to his head. He had been beat on It was pretty severe.
Okay. And were you able to speak to anyone about this incident?
I spoke to the lady who flagged me down, a couple of witnesses. They pretty much said that they were trying to go to the barber shop, and the guy came to the door and was like, they said that this motherfucker's closed for the day and wouldn't let no one inside and wouldn't let the victim leave.
Okay. Did these witnesses see anything after was it this guy? Was that the defendant that said this motherfucker's closed for the day?
Yes.
Okay. So after that was said, did the witnesses see anything else or advise you of any other information?
Hold on, let me refer to my report real quick. Oh yeah, so he did come to the door for the. Just saying report that he did come to the door for the witnesses, and that's when he told them that it's closed, and he proceeded to shut the door and lock it.
Okay. And how did you determine that you stated that that Damian Bradbury beat on the victim here? What was the victim's name?
The victim's name is going to be Mr. Willie Huey.
Okay. And how did you determine that the defendant had caused the injuries to Mr. Huey?
The statements from the victim and actual physical evidence on the scene.
Okay. What kind of statement did the victim make to you?
He made a couple statements. He had suffered the head injury. He stated that the guy came in there demanding money from him, and he said he wasn't going to give him any money. And the guy, that's when he physically assaulted him.
Okay. And Mark, when you say physically assaulted him, did you get any more description of what that physical assault involved?
Hit him in the head.
Okay.
And I want to say he hit him with a bottle, a plastic bottle.
Okay.
Of liquor.
Okay. And you say that he demanded money. Was any money taken from him?
Yes. We found out later that there was actually money taken from him.
Do you know how much?
Let me see. We recovered $56.67 off of his persons.
Okay. And this was,
money had blood on it.
And this was on the person of?
This was on the suspect, Mr. Bradbury.
Okay, thank you. Okay. Yeah. Okay. So do you have a copy of the warrants in this case?
Yes, sir.
Okay. So I just, if you look down to the probable cause section, I just ask you to look to that third paragraph. It's a short paragraph, and just read it and refresh your memory.
The one with Brittany, when I spoke to Brittany Moses.
Correct.
Upon speaking with witness Brittany Moses, she stated that upon her attempting to go into the business, a male covered in blood came to the door and advised her that this motherfucker is closed for today. Moses stated that the male then locked the door and started to punch the victim in the head.
Okay. And are you the one that spoke to Brittany Moses?
Yes, and it was recorded on body cam as well.
Okay. So you also issued a warrant for abuse, neglect, or exploitation of a disabled person?
Elderly abuse.
Or elderly person, yeah. Yes. How did you come to the conclusion that was an appropriate charge?
I'm ACT certified, and the male is well above the age. He was born in 1950. Okay. And he beat on him.
Okay. Did you get any indication that he targeted, that Mr. Bradbury targeted Mr. Huey because of his age?
I can't speak on that.
Okay.
Because I'm not sure if that's what it was.
Okay. Did you get any indication that he knew or should have known what age Mr. Huey was?
From my understanding, they did have history.
Okay. Okay, thank you. You also issued a warrant for false imprisonment. How did you come to the conclusion to issue that warrant?
By him locking the victim inside of the business and not allowing him to leave. And when I got on scene, he wouldn't allow the victim to leave.
Okay. Okay, thank you. Did you get an indication that the victim wanted to leave or attempted to leave or?
Yes, the victim was very frantic. I mean, he had suffered several injuries from Mr. Bradbury.
Okay, thank you. And this location, do you have the address for this location?
Yes, it's going to be, let me grab it. $782 Cameron M. Alexander Boulevard.
Okay. And is that in Fulton County?
It is in Fulton County.
Okay. And do you see Mr. Damian Bradbury in court today? You can stand up if you need to. Yeah.
Everybody remove the mask?
Yes, that's it.
Okay.
He's right there with the jumper.
Okay. The court note for the record that the witness in this case identified the defendant, Damian Bradbury.
Noted.
Okay. No further questions for this witness, subject to redirect.
Go ahead, Mr. Lang.
Morning, Officer Cunningham.
Good morning.
My name is Attorney Lang. I represent Mr. Bradbury today. I'm going to ask you some questions of my own, follow up on some of the questions you were asked by ADA Pennington. Let's start with, so the property that this happened at, what was the nature of the property? Was it a business? Was it a residence? It was a barber shop? Okay. I know you approached via the front entrance, correct?
Yes.
Are you aware of whether the property had a rear door as well?
I'm not aware of the rear door.
Were any statements made to you by anyone about a back door or any other way in or out of the property?
No.
Okay. You said you believed there was a history between Mr. Bradbury and Mr. Huey. Do you happen to know the nature of that history?
Not to any extent that would be beneficial to the case. The victim did state some things, but that's beyond me on this case right now.
You already kind of alluded to it in direct, but your body worn camera was on and active the entire time?
Yes, sir.
Do you know if that video has been recorded to Axon or evidence.com?
Yes, sir.
Okay. Do you know if the property itself had any surveillance footage?
Not from my knowledge.
Do you know the current status of the victim?
No, sir.
Okay. No further questions at this time, Your Honor.
Any redirect?
No, Your Honor. May this, the state has no further witnesses. May this witness be excused.
You're fine with it? You can be excused. You sure? I can help you with a haircut.
They're probably gonna call me tomorrow. I'll get you tomorrow.
That's all right. Stay safe out there.
Yes, man. I appreciate you.
Good to see you again.
Oh yeah, see you tomorrow.
I'm gonna bring some clippers just in case. All right, I'll help you out. All right, go ahead on argument.
Your Honor, I will submit to the court on the bottom two charges. However, on the false imprisonment charge, I do think there's an issue here with this being a business location. Most business locations have a front and rear door. While the officer was unable to testify to any specific information about the rear entrance to this building, he was also unable to tell us that that entrance was locked and inaccessible to the victim in this case. False imprisonment requires that you prevent the person from leaving in any way. If there is a back door here that was unlocked, while I understand the circumstances that were alleged to in this case, the victim very well could have had a second way out of this building. Therefore, it would not rise to the level of false imprisonment. I understand that we don't have the concrete, yes, there is a back entrance, yes, it was unlocked, but we also don't have information fully providing that the only means of entry in and out of the building was inaccessible to the victim. So for that reason, I'm asking the court for no probable cause on that charge.
All right, Mr. Pennington.
Yes, Your Honor, we had a witness at the scene that came to the location. As I'm responding to the false imprisonment argument that stated that the defendant locked the door when the witness was there. The door was locked, and he stated that the business was closed for the day. These witnesses would have had a chance to help out the defendant potentially, but were not allowed to. This further indicates that the victim was not free to leave. The state submits on the evidence on the other charges. However, the state would like to add a robbery charge here in this case. There was originally a robbery warrant taken out. The robbery warrant was dismissed at first appearance. I don't have the exact, I was not part of that first appearance, but it's presumably because on that it was not listed exactly the property that was taken. The officer has testified to that now, that the money was taken at and the amount of money that was taken from the victim. So that we believe that probable cause exists for a robbery charge in this case. And that given the facts available, that should be added now.
You want to respond while I'm looking at that?
Yes, Your Honor, I would ask the court to hold off on adding that charge at this time. If that's information the state wishes to proceed on, it can be handled at indictment at this time. That charge was initially dismissed at first appearance. I believe the proper remedy would be to re-indict on that charge, but at this time, I'd be asking the court not to add that charge.
Your Honor, when something's dismissed, I just want to respond to that. When something's dismissed at first appearance, this here is a probable cause hearing, so that, it is appropriate to reconsider the probable cause from something heard at first appearance at a probable cause hearing.
Right. I looked at, and some of the warrants are defective when they say committed a theft, but they don't say what. So we'll add that. Go ahead with your bottom. Oh. Wow. I'll find probable cause on all that and add robbery. She just wants me to sing to her again. Are you listening, Miss Jackson? We are for real.
All right, the defendant has 14 cycles. The defendant's last arrest was May the 14th, 2022 in Fulton County for simple battery. That case appeared to be still pending. That case number is 22 MAGCS 2550. Also, the defendant appeared to be on probation in Fulton County for aggravated assault. That case number is 18 SC 161591. That disposition date was December the 19th, 2019, and the term is for 3 years. The defendant appeared to have additional case that may have ran concurrent with that case. It's for aggravated assault as well. That case number is 19 SC 170482. That disposition date is the same, December the 19th, 2019, in the same term, 3 years. The defendant does have a prior felony conviction. Well, actually, it was in 2021 for aggravated assault. It was confinement for 8 months. If you like that case number, I can provide the courts with the case number, Your Honor.
Do you want it, Mr. Lynch? I've got it on that.
I'm okay for right now, Your Honor.
We're good.
Okay. Also, the defendant has a history of failure to appears. There were 2 in 2018. Nothing in addition, Your Honor.
All right. Go ahead, Mr. Lang. And it says on here he would be homeless. So.
And Your Honor, at this time, I do not have an updated address for the court. This is the case where there are substantial MH and substance abuse issues at play. As I mentioned, Your Honor, earlier, I believe this is a case that a sealed order may be getting filed in. Based on the information I have at this time, the IALA factors I can present to Your Honor. He's 32 years old. He did graduate from high school in 2009. He had his CNA license before he kind of entered the period in his life where he is now with the issues I mentioned and with the housing instability at this time. I'm asking the court to set a bond since he is eligible for a bond, having been in custody for over 90 days. I will leave the dollar amount and the reasonableness of that amount to your honor's discretion. Understanding that this is a case where no matter what the amount is, I don't believe Mr. Bradbury will have the means of affording that bond. I'm going to focus primarily on getting treatment for the issues I've mentioned, and then we'll readdress bond from there.
All right. Mr. Pennington.
Yes, Your Honor, the state believes this defendant's risk to reoffend and a danger to the community, danger to this victim in particular. The state would ask for a no further contact with the victim, Willie Huey, in this case, a 24-hour curfew. I realize this victim's homeless and that may present a problem for an ankle monitor, but this defendant needs to be monitored. Additionally, Your Honor, the state would ask that there be the defendant have no weapons and whatever other conditions the court deems appropriate. The state just asks for a bond and reasonable discretion of the court.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Willie, last name HughleY. Stay away from 782 Cameron M. Alexander Boulevard. That's Banks Barber and Style Shop. You're gonna have an ankle monitor paid for by the ORCA project with a 24-hour curfew, court, lawyer, medical, or any programs that the public defender's office gets you into. So you're gonna have to supply an address to get out. You have to supply an address where you're living, and I'm sure Ms. Cole, and then we're gonna be working on housing for you. So you'll have an address there to supply, but you have to supply that to the jail upon being released, give it to Ms. Cole. They can supply it to the state and they can put in an address for you, but we have to know where you're living. And it's important because you got to keep that ankle monitor charged, okay? I did that for you. Go ahead. You can
Hold on one moment. Let her finish what she has to say, and then you and I will talk. So let her finish what she has to say.
Just trying to help you out, okay? Because that they're taking notes over there. So we're false imprisonment. We'll make 10 abuse, neglect, 20 battery, 20 robbery, 20, 10, 20, 20, 20. I don't think there were any holds. I didn't see any.
Not that I saw.
Sorry, Madam Court Reporter didn't want that picked up what he was saying on the record.
No, I can't hear that, what they're saying.
Thank you. Is that it, Mr. Lang?
Yes, Your Honor, we're all
All right. Best of luck to you. Are we getting a reset date on this one? Do you want a reset date for the prelim?
The prelim just happened.
I mean, I'm excused. I was talking about the other one, the next one, I think, where the officer's not here.
Oh, yes. You're talking about position 8?
Yeah, it's 8, yeah.
And we already have a reset date there for January 17th.
So I think we were just going to do a bond hearing on that.
Bond on that? Okay, yeah. Sorry, I did flip the page. 17th. Do we need dates on anything else or are we good?
Yes, Your Honor.
Excuse me, Judge.
Back to the back. Go with her.
What's up, Ms. Holmes?
Can I ask the ADA his name so I could put it on position 5 consent bond order?
Yeah, Timothy Pennington, common spelling, P.
Thank you.
Okay.
Yes, Ms. 8. See, Mr. Pennington, this keeps him off my huge night court calendar.
And then the last one we need is Maltsby.
We are all for getting rid of the night court calendar. Like we are on board with that. If we could,
Y'all don't like me doing night court?
no, if we could get it done in prelims, that would be fantastic.
Your Honor, it's not that I don't like you doing night courts, that I don't like doing night court.
But we move them quicker.
We do. I mean, it amazes me the number of times we'll have 40-person calendars there and we're done within 45 minutes. We rail through it. It's incredible.
We got it
still
down to a
doesn't mean-
science, but the
Still doesn't
private,
mean I want to be working after 5.
yeah, but the private attorneys just take so much longer.
Yes.
I've had to tell them what IATA factors are many times, like
Well, we don't have Miss Bostic here today, but Miss Bostic usually sends me a message letting me know what my word count is for the day.
Busted.
Send me a message letting me know, hey, you got 100 words today. I know you got 10 cases, so you get 10 words per case. You know, keep it.
She told Rockwell she had 20.
Rockwell, I'll take the 20 just to say hello.
Bless her. She has worked hard from her very first days.
Oh, absolutely. I wish I could be half the lawyer she is.
She has worked it. Do you remember her when she would like just be here, back when they used to just appoint lawyers in the courtroom? Like, we need a lawyer, and they'd be like, he's your client. You're going, what? She picked up a ton of cases like that. All right, this is position 8. 22 CP 212314 Theodore Maltsby, Mault SBY, 94 days without indictment. There's no bond on aggravated assault. Rah.
The defendant has 44 cycles. The defendant's last arrest was January the 9th, 2020 with the City of Atlanta Police Department for possession and use of drug-related objects. There was no disposition for that arrest. The defendant does have prior felony convictions. There's one in 2005 out of Ware County for a felony obstruction of an officer and robbery, and one in 1993 out of Ware County for burglary and robbery, and one in 1991 out of Ware County for burglary. The defendant does have misdemeanor convictions. So one in 2017 for battery, an additional one in 2017 for obstruction of an officer, and one in 2013 for theft by shoplifting. Nothing in addition, Your Honor.
All right. Go ahead, Mr. Lang.
Yes, Your Honor. Mr. Maltsby is 59 years old. He has lived in Georgia his entire life. He was born in Waycross, Georgia, lived there for the earlier portion of his life, moved to Atlanta recently to try to get a new start after both of his parents passed away and one of his older sisters passed away. He kind of wanted to move to a new city and try to restart life over here. He completed the 11th grade. He was working on his GED, but has not yet completed it. He has 2 daughters, both in their 30s. One lives in Valdosta, one lives in Jacksonville. He, like I said, he's lived in Atlanta for the last 10 years. About 3 years ago, he did have a medical emergency. He had a stroke, which impacts his speech and memory, and has kind of helped him reestablish contact with his daughters, them helping him through this process at this time. He was working for a restaurant called The Food Shop on Lucky Street. He'd been there for about 2.5 years, kind of doing just general labor around the facility, helping with cleaning, taking out the trash, doing dishes, when needed, helping out the chef at that location. The chef has been a friend of his for about 8 years. We have spoken with him, who confirmed that information, confirmed that Mr. Maltsby has worked for him and will continue working with him. Looking at all of the information presented, while I do understand when you hear from the state, they'll probably give their proffer of the facts in this case. It is worth noting that since the origin of this case, Mr. Maltsby has identified to officers a self-defense argument in this case. It is something we continue to stress in this case, continue to explore. There was a knife recovered on the alleged victim. My client was stabbed and injured during this altercation as well. Based on that information, I am asking the court to set a reasonable bond. We are looking into potential treatment options for a substance abuse issue, but I do not believe there's any issue that would rise to a sealed order or anything to that effect in this case. So I'm asking the court to set a reasonable bond. I would ask the court to consider $10,000, but total, I'd ask the court not to exceed 25.
Is there an address where he'll be living?
The address I have on record is the one on his booking sheet,
An avenue?
18 Wayman Ave. Yep, that's the address I have as of right now. I do not know the current status of that housing, to be candid with the court. It will be something we're looking into for maybe a housing program as well, if he is unable to return to that address. But as of right now, I have no reason to believe that he cannot.
Yeah, on the pretrial report, it's Westchester. So.
You mean the addresses?
Uh-huh. Yeah, on the pretrial report, he gives a Westchester address.
And I'm not sure which of those would be the primary one at this time, Your Honor. I'm also looking at Ms. Cole's notes, but it is something we're looking into about whether there is stable housing at this time. I have no reason to be able to tell the court, no, there is not at this time.
Mr. Pennington.
Yes, Your Honor. In this case, the state is most concerned with the violence shown in this incident that's outlined in the warrant. Not only did a stabbing occur, but this appears, based on the warrant, to have been a rather random crime, which presents a danger not just to this victim in particular, but to a danger to the community as a whole. Additionally, would note while the defense did note that they will have a argument about self-defense. The officers at the scene also assessed that and were able to watch video, according to the warrant, which based their determination of a aggravated assault being perpetrated by the defendant based on video, which showed the actual assault. So the state just requests a bond, which reflects the danger to the community here. Additionally, the state would request no further contact with the victim in this case, no weapons, an ankle monitor with a 24-hour curfew, whatever other conditions the court deems appropriate. That's all, Your Honor.
Any follow-up?
Just with regards to the argument about the video, Your Honor, one of the key elements I was going to question the officer about during the preliminary hearing, had they appeared, was whether or not my client was exhibiting a stab wound in his chest when he appears on that video footage, because at that time he had already been stabbed in the chest with a box cutter by the alleged victim in this case.
I got you. All right. No drugs, no alcohol, no weapons. Stay away from, there's a couple addresses here, 135 Andrew Young International Boulevard, and also 120 Ted Turner Drive. And looks like one of these are close to us. So all Waffle House restaurants. Heartbreaking. Don't go around any more Waffle House restaurants, sir. No further contact with Oscar Johnson. You're gonna have an ankle monitor paid by that ORCA project with the 24-hour curfew except for court, lawyer, medical, or any programs that Ms. Cole / although it's Mr. Lang today, your attorney gets you into. And sir, no weapons is a knife, a hammer, things like that. If you can make it into a weapon, it's a weapon. Be used as a weapon, so you can't have weapons. You can't carry around a knife, all right? $30,000 good bond. You must supply your address before you release of where you're going to be staying, okay? Let them know at the jail. They'll let Ms. Cole know, and so on and so on. Best of luck to you, sir. You got all that, Ms. Holmes?
Yes, Judge.
You gonna text me when they're all in the queue, or are they all already there?
I have 2 more to do. And I'll text you.
All right. You with us tonight, or is that
Go with this young woman right here. She's going to tell you what to do.
No, it's not me. I think it's Miss Rowe.
oh,
I
okay.
think. Well, whoever it was Tuesday. Monday and Tuesday.
All right. Anything else we need to put on the record, or can we?
That concludes my business here for the day.
Believe that concludes ours as well.
All right, Madam Court Reporter, is there anything you needed, spelling of names, et cetera, et cetera?
Y'all are wonderful. Judge, you are wonderful to work for, and I've enjoyed it. Thank you.
Thank you so much. Such kind words. Thank you. I don't get many of those, but thank you. Yeah, Ms. Holmes is always nice to me. All right, you guys have a good afternoon.